A very good morning to all my dear students. Today we are going to discuss about the concept of appearance and non-appearance of the parties in a civil suit. Before starting with this topic, that is appearance and non-appearance of the parties, I would like to mention certain important facts which is of immense importance for the proper understanding of this topic. As you all are aware that the purpose of the courts is to administer justice and thereby to give access to justice to each and every person in this country. Furthermore, this access to justice cannot be achieved without there being proper legislations to this effect. For this purpose, the legislature has divided the law mainly into two branches. These are substantive law and another is procedural law. As you all are aware that substantive law provides the rights and duties of the parties, whereas procedural law provides the procedure to achieve the ends of justice, whereby to give effect to the rights mentioned in the substantive law, meaning thereby both substantive and procedural laws are supplementary and complementary to each other. As such, this procedural law provides certain steps for instituting a civil suit in a court of law, and some of the steps involved in the instituting the suit are: number one, there must be a cause of action, and that cause of action must be mentioned in the or must be averred in the plaint. And once the plaint has been drafted, then the same needs to be presented to a court of law. Thereafter, after looking into the said document, the court may admit that plaint and register it as a civil suit in the court of law. Thereby, it becomes the civil suit. And once the civil suit has been admitted in the court of law, the court thereafter gives another opportunity of being heard to the other side, that is the defendant in the case, thereby to put his appearance before the court of law on a certain date in respect of the case filed by the plaintiff, and also gives him an opportunity to file its written reply in the said civil suit. And if if the defendant thereafter files the written statement in the said case, the matter thereafter be listed for appearance and non-appearance of the party. Now I will start with the said topic. The object behind appearance and non-appearance of the parties is that no proceedings in a court of law should be conducted to the detriment of any party in his absence, and thereby to give him full access to justice and also to give him a fair trial in the said case. This may be contemplated or must be read in reference to the provisions laid down under the administrative law, and those principles or the grounds laid down under the administrative law is that of principles of natural justice, and one of the principles of natural justice is audi alteram partem, meaning thereby to give an opportunity of being heard to the other side, and also to ask him to appear before him on a certain date, so that this opportunity must be effectively given to the accused, thereby to achieve the ends of justice, and also to confirm or thereby to achieve a fair trial in a civil suit. Order 9 CPC enacts the law regarding the appearance of the parties and the consequences of their non-appearance. It also provides a remedy for setting aside an order of dismissal of the suit, and also setting aside of the decree passed against the defendant. So from this, we may infer that two types of order can be passed against the defendant in case if he fails to put his appearance before the court of law on a certain date. The court may pass an ex parte order against him, and also may pass an ex parte decree also against him. There are total 14 rules contained in Order 9. Rule 1 and Rule 2 lays down the principles regarding appearance of the parties. Rule 1 empowers the parties or requires the parties to attend the court in person or by their pleaders on the date fixed in the summons for the defendant to appear. And Rule 12 provides that where a plaintiff or a defendant who has been to appear in person does not appear in person or show sufficient cause for non-appearance, the court may dismiss the suit if he is the plaintiff or proceed ex parte if he is the defendant. So this Rule 12 talks about the grounds for non-appearance of the plaintiff, and this is subject to the condition that if sufficient reasons been shown for his non-appearance, then the court may set aside the dismissal of the suit against the plaintiff, or if it is a case of defendant, then there are three possibilities where neither party appears, where only plaintiff appears, and where only defendant appears. Then what would be its consequence on the suit? Now, I will straight away come to the first point, that is, where neither party appears, meaning their appears. Then what would be its effect? On the certain date or the date given to the parties, if both parties do not appear before the court on the said date, the court may dismiss the matter or dismiss the civil suit. But this dismissal of the suit under Rule 3, however, does not bar a fresh suit in respect of a cause of action. Therefore, we therefore we may infer from this provision that if sufficient cause being shown by the plaintiff or by the defendant on the next date of hearing, then court may set aside the order, or if they have filed a fresh suit regarding the matter, then the court may entertain the suit again, and this would not be barred by barred by section 11 of the CPC or barred by order 2 rule 2 CPC would not be applicable, because full trial has yet not been completed and both the parties are at the fault. So a benefit of doubt may be given to the parties in this circumstance. If the court is satisfied that there was sufficient cause for his non-appearance, then the trial court shall pass an order setting aside the dismissal of the suit and shall fix a day for proceedings with the suit. So from this, we may infer that plaintiff have two remedies in case neither party appears. First remedy is to file a fresh suit on the same cause of action, and second remedy is to file an application before the same court where the suit was pending. And if sufficient cause being shown, then that particular court may set aside the order and fix the matter for proceedings with the suit. Next, where only plaintiff appears. So now I am talking about the circumstance in which where only the plaintiff appears and defendant does not appear. Then what would be its consequence? Relevant rules pertaining to this are given under Rule 6 to 10, where the plaintiff appears and defendant does not appear. The plaintiff has to prove the service of summons. As you all are aware that it is the duty of the plaintiff after his suit has been admitted to approach the court and thereby fills the process fee form and also to serve the summons on the defendant. And if the service of the summons is proved by him in the court of law, then the court may proceed ex parte against the defendant and may pass a decree in favor of the plaintiff proving his case. So the repercussion would be on defendant herein. And the repercussion or the consequence on the defendant is that either he may be proceeded ex parte or an ex parte decree may be passed against him. So from this, we have to distinguish between what is the difference between ex parte order and an ex parte decree. In the case of an ex parte order, the defendant can participate in further proceedings apart from the proceedings dealt on the date in which he was absent. But in case of the ex parte decree, nothing remains left. So he is, as there was no suit pending before the court. So defendant would either have to file a setting aside application before the same court or move to the higher courts for the appropriate remedy. But as far as the proceedings, as there was no proceeding, so no question of any proceeding or being proceeded in the matter could arise. Next, this provision, however, is confined to the first hearing. What do you mean by first hearing? First hearing means after the issues has been framed, then the matter would be fixed for fixed hearing. And the fixed hearing is given under Order 15 of the Code of Civil Procedure. Hence, this provision is confined to first hearing and does not per se apply to subsequent proceeding. So, from this, we may infer that it would not be applicable to subsequent pleadings. Next, where only defendant appears. So we have already discussed till this particular point of time where neither party appears and where only plaintiff appears. Now we are going to talk about where only defendant appears, and the relevant provisions are Rule 7 to 11 of Order 9 CPC. Where the defendant appears and the defendant does not admit the plaintiff's claim wholly or partly, then the court shall pass an order dismissing the suit, meaning thereby, if the defendant on being appeared before the court does not admit the amount claimed by the plaintiff in the suit, then the court shall dismiss the suit at its threshold. Second, but if the defendant admit the plaintiff's claim wholly or partly, the court will pass a decree against the defendant upon such admission and dismiss the suit for the rest of the claim. Further, it precludes the plaintiff thereafter from filing a fresh suit on the same cause of action. He may, however, apply for an order to set aside the order of dismissal. So from this, we may infer that there is a distinguish between Rule 4 and 5 and Rule 7 and 8, whereby under Rule 3 or Rule 4, as the case may be, where there is no bar on the fresh suit, in this particular circumstance, if the plaintiff does not appear and the defendant appears, then the fresh suit is barred himself. So he will have to bear the consequences with regard to it. But however, he may be given an opportunity before the same court, and thereby he prays before the court for setting aside the order of dismissal. Next, if the court is satisfied that there was a sufficient cause for his non-appearance, the court may set aside the order of dismissal and fix a day for proceedings with the suit. Next, where summons is not served, Rule 2 to 5. What would be its consequence? As you all are aware, that summons is one of the notice given to the party to appear before the court of law on a certain date and thereby to give its reply qua the suit filed against him by the plaintiff. So where the summons has not been served, then what would be its repercussion or its consequence? The consequence would be that no decree can be passed against him. Further, Rule 2 enacts that the suit may be dismissed where the summons is not served on the plaintiff's failure to pay cost for service of the summons to defendant or to present copies of the plaint. If there is a fault on the part of the plaintiff, thereby summons could not be served to the defendant in due time given by the court or as stipulated under the Code of Civil Procedure, then the court may dismiss his suit as he does not fulfill its duty given under the law, meaning thereby everyone has to come or has to approach the court with clean hands, as his hands are not clean. As such, he would be barred from filing a fresh suit. Next. So this is all about today's topic on this. Hope you have learned a lot from it. In case of any doubt, you may contact me at my email ID, that is rahularoda.gn@jagannath.org. Before parting with the today's lecture, I would like to let you know about the new topic which I am going to take in my next lecture. In my next lecture, I am going to deal with the concept of ex parte decree given under Order 9, Rule 13, and thereby to apprise you about its consequence and how this ex parte decree can be set aside by the court and what are the remedies available to the defendant. Hope you have a great day ahead. Stay home, stay safe, and be positive. Thank you very much. We'll meet you soon.